All right, I think this is as good a time as ever to get this started. Hello, David. How are you?
Hey, good afternoon, Rob. How are you?
I'm doing great. Welcome everybody to Garfunkel Wild. This is our compliance department's monthly webinar series, and we are back today with my partner David Traskey, and we're here to conquer part three here of this series, David, and that's the topic today is the OIG's role in the False Claims Act cases and the resolutions, things that, you know, frankly, we deal with all the time and our clients fear, but I think this is a great opportunity for everybody to kind of get an inside look from you about how the OIG, works with DOJ and U.S. attorneys' offices. But why don't you remind people, kind of who you are and what you're doing? And as a reminder to everybody coming in, this is being recorded. We are going to send it to you after it's done. So I know it's always my favorite questions that come up all the time, but everybody who registered will probably get this out to you tomorrow. So David, again, let's remind everybody before you joined us here at Garfunkel Wild, where do we snag you from?
So first off, I just want to thank everybody for joining today, and I know we've got a really great turnout, and in particular for those of you who have rolled with us for all three sessions, we really appreciate that. But yeah, just by way of brief background, I came to Garfunkel in May after spending nearly a decade at the U.S. Department of Health and Human Services Office of the Inspector General, and before that, I worked for the Department of Veterans Affairs, both within their department and within their Office of Inspector General too. And I think sort of most relevant to us today is my work with the OIG for HHS. And in particular, for this discussion, I handled many issues while I was there over the years, including representing OIG in settlement discussions with DOJ for Civil False Claims Act cases. And I also spent quite a lot of time negotiating and then later monitoring OIG integrity agreements.
All right, terrific. And we're so glad to have you. I knew where you were from because we were on the opposite sides of each other there a few times. But now that we've covered self-disclosure protocols, we've covered affirmative litigation, and now today we're here to talk about that other part, and that is the role in the False Claims Act cases that are being brought very often by the U.S. attorney's offices and by DOJ down in Washington. And how would you kind of divide up the OIG's kind of involvement in these cases?
Yeah, so I think one thing as you pointed out, right, the volume I think of cases that are being brought under the False Claims Act are increasing. I think that DOJ's involvement in them and OIG's involvement in them is also growing, as well as the number of cases that go on their own without government involvement. But for for the purposes of today, I think the thing to take away, one of the things to take away is that the OIG's involvement in those cases sort of, in my mind, falls into three different buckets, right? You have the investigation bucket, you have the negotiation bucket, and then you have the resolution bucket.
Right, right. So I think we'll get into all three of those, but just as a background, right? The False Claims Act has really been the government's weapon of choice when going after providers for potential healthcare fraud, and it's resulted in billions of dollars in recoveries for the government. In those cases, start off either through a direct investigation for some reason. Are they data mining? Are they looking at you're an outlier for some reason, or are they getting a whistleblower who's coming in and someone maybe from your own organization going out and letting them know that there's an issue here. And so you know when we get into these cases, oftentimes, on my side, I'm receiving my clients are receiving civil investigative demands, sometimes subpoenas, and they're coming to us and they're coming to us for help, and there's a healthcare investigation underway. But we're usually interfacing with the U.S. Attorney's Office or Department of Justice attorneys, and that's really what's on my desk, 9 times out of 10. But in the background, as experienced attorneys, we know OIG is there. We know that that day, assuming that there is, a resolution and liability, a liability and a resolution, there's coming a day when we'll be talking to you or talking to the OIG about different aspects of the resolution. But I don't think a lot of people understand what has been happening in the background. When is the OIG getting involved? How does that interrelationship work? Who's communicating with whom? And so, like, let's talk about that investigation phase. So when that CID is hitting or that investigation is going on, what should people know, or what can they know about what's either happened already or is happening at the OIG?
So I think that one of the key takeaways here is that understand by the time someone is receiving a CID or they're getting a phone call from the DOJ or a visit from an investigator, that there's a lot of things that have already sort of happened in the background, right? And one of those things is that that the OIG in conjunction with DOJ is participating in an investigation, and that they've already done things to further that investigation before kind of reaching out to to a target or to counsel for a target. And so the way that it would typically work is that let's just take the most common way for FCA cases to sort of bubble up is through a whistleblower complaint, with a relator. And so once those are filed with the court, DOJ typically would reach out to the OIG, provide a copy of that complaint or an amended complaint if there is one, maybe some of the exhibits. And essentially, from at that point, the case comes to the OIG, to the Affirmative and Civil Remedies Branch, the ACRB, and those cases are handed out based on the geographical region to one of four teams, and you'll have a line attorney. There's typically 5 to 7 line attorneys on each team, and they'll be the sort of the first touch point to look at that complaint, to read it, to assess it, to see
Yeah.
um,
So when
what's
that was you, when that's hitting your desk, okay. So what are you looking for? What are the things? Obviously, you're reading the complaint, you're doing the things that, the complaint we'd love to get our hands on earlier, obviously, but
yeah.
you've got it
Yep.
and you see what's going on. What are the things that are of most interest to you back when you're in the OIG?
Yeah, so for me, the first thing I'm probably going to do is read the complaint, and then I'm going to reach out to the OIG's Office of Investigations, because generally speaking, there's an OI agent who's assigned to the matter, and so I'm going to reach out to that agent, and I'm going to get a little bit of background on how the case came to be, what investigative steps have taken place to date, kind of sort of get the general feel of of the case and the legal theory behind it, and to understand kind of what steps are going to be what the sort of the plan is going to be moving forward in terms of different steps. And then, when I'm reading the complaint itself, I'm really most interested in, seeing whether or not the theory and the facts support resolution under the False Claims Act.
Right. And are you also taking a look through, the cases are brought under the False Claims Act and some other theories of liability, but you're also sitting there with civil monetary penalty, enforcement authority. So are you also starting to take a look at things at all from that point to look at the play? Are you looking at the players at all in
Yeah,
this?
yeah,
Trying to get a
absolutely.
feel?
Yeah, absolutely. It's a great question. Absolutely. So, as part of that, you're going to be looking at what other OIG authorities we might, bring to bear in that case, whether it's the civil monetary penalties law or whether it's exclusion and things like that. And you sort of, are at that preliminary phase working to get an understanding of who the key players are, not only if it's an entity, but also whether or not, who the key individuals are. And I think it's through that information that you can start to assess, whether or not, a particular conduct or a particular entity or individual, how you might consider either further investigating and or looking to sort of see what a potential resolution would maybe look like if we get to that point.
assume you're also trying to take a look and see whether is this person somebody we've been, the OIG's already been looking at maybe independently or has come up across your radar at some points in time, or are they a prior
Yeah.
offender or
Yep.
anything
Yeah. I
like
mean,
that?
as big as the healthcare space is in the United States, there are some individuals and entities who, for a variety of reasons, end up on our OIG's radar as a frequent flyer. And so that's also one of the things that we would be doing is sort of taking a look and see what is the prior history, if any, kind of with this individual or entity. Have they settled with us before? Have they settled with DOJ before? Have we investigated this entity or individual before, but maybe close the matter for whatever reason? And kind of see generally what we can learn about, the individual or the entity that's being investigated.
And then what about as it relates to, particular rules or regulations that may be implicated for the different federal healthcare programs? Are you consulted with at all about either application or interpretation of anything? Does DOJ or the U.S. Attorney's offices turn to you or the OIG at that point in time and look for guidance on the application and enforcement? Does anything like that take place?
It does sometimes, and I think it really is just sort of a function of when those things happen. A lot of it is based on the U.S. Attorney's Office or the main justice attorney that's assigned to the case. Through my years there, I was able to develop a lot of relationships with different attorneys, U.S. attorneys, or AUSAs across the country. And in some offices, I think are more willing to reach out to the OIG, for as a collaborator for guidance than others. And however they want to do it is okay. But OIG is there, and I think a lot of times what some of the common questions that the OIG attorneys in ACRB would receive would be either, hey, from the U.S. attorney, hey, can you put us in touch with somebody from CMS who could answer a question about X,
Right.
or how do sort of, or how does how does HHS tend to interpret Y, or something like that. And sometimes the OIG attorneys are able to answer those questions. And sometimes they work as sort of a facilitator to put the U.S. Attorney's Office in touch with somebody from either the Office of General Counsel at HHS or maybe someone in CMS, if it's a pretty specific or nuanced question.
Right. Yeah, sure, sure. And so then what happens? Is there kind of a conclusion to this phase, or um kind of where do things kind of culminate? Obviously, you get this across your desk, you're looking at the players, you're looking at the issues. What happens next?
Yeah. So, I mean, again, as the investigation phase kind of is, I won't say that it ever really sort of fully wraps up until everything is said and done, but it sort of, as it winds down and you sort of start to look at, if there's an appetite for or an interest in negotiation, we that's where we sort of start to focus in on, do we, can we support the elements if a case were to be brought under the CMP or under the FCA, something like that. You're looking at the requirements that you have to, burdens that you have to carry, if you're the government. But then also sort of towards the end of that investigative stage, depending on when OIG is brought into the process, there's typically a conversation with DOJ about whether or not DOJ will intervene in the complaint, either in full or in part. And that conversation doesn't happen all the time. But
Right.
when it does, the attorney at OIG is going to then sort of take that information, and they're, essentially DOJ is looking for a recommendation from OIG at that point. And then, the line attorney at OIG is going to look at all the information that he or she has. They're going to prepare a memo, for their supervisors, and there's going to be a conversation with those supervisors in addition to a review of the memo, to be able to advise DOJ sort of what the OIG position is on a particular case.
Okay. And now, so in those cases, we have, out with the lead on the case, we have U.S. attorneys and the DOJ attorneys, and then what when do things kind of circle back to your office? I mean, I'm always used to, you know, the late introduction, right? It's I've kind of have a handshake, we've kind of worked through a lot of the things, and more times than not, unless it's some kind of novel issue, um, where it's a late introduction, but things are obviously happening. So what's that next phase of, or that next bucket where you put the OIG?
Yeah, so I think that, if you're in a posture where you're discussing settlement, and the parties are sort of working to get to that point, the next phase that you will sort of see the OIG is probably in the negotiation phase in looking at settlements. Um, so again, sort of in the background, what's happening is that if there's a tentative agreement to settle a matter, at the DOJ is going to circulate a draft settlement agreement to settle the matter under the False Claims Act. Uh, and oftentimes before it goes to defense counsel or the target, it's going to come to the OIG attorney, and that attorney is going to review um, that draft settlement agreement and maybe provide feedback on the agreement. Typically, the feedback comes in, I think, probably two spots. One is either is the description of the covered conduct that's being released under the settlement agreement, or questions about the damages calculations. And those are conversations that would happen internally between the OIG and the DOJ attorneys. And then also one of the things that OIG is going to be specifically looking at in those settlement agreements is to make sure that OIG's authorities are being released or not appropriately,
Right.
or effectively. Because you remember, the FCA, for the False Claims Act, for example, that's a DOJ authority. It's not an OIG authority. But
Right.
then, as we talked about, there's other things under the CMPL, Civil Monetary Penalties Law, and exclusion. Like those are OIG authorities. And so, to the extent that there is a settlement agreement that incorporates all of those things, that's what OIG is going to be focused on as well.
Right. And that's where we start getting into kind of the heart of this, and probably some of the more interesting parts for this discussion is, right, exclusion, or integrity agreements and things like that. Before the client and their counsel are interfacing with the OIG, what kind of discussions are you, or determinations are you making as the OIG, and what kind of discussions go on with the U.S. attorneys offices and DOJ about that before defense and their counsel are even introduced to this aspect of the case?
Yeah. So aside from conversations about sort of the settlement agreement and the information that's contained on the four corners of those documents, the other thing that OIG is going to discuss internally, but also with their DOJ counterparts, is two things. One is whether or not exclusion is warranted in this matter, and if it is, kind of what their proposal is in terms of the number of years. And then if it's not warranted, then the second question is, okay, it's not exclusion worthy, but do we need to impose some sort of additional integrity obligations to protect the integrity of the healthcare system? And then the last one would just be, aside from a monetary recovery, do we need, maybe we don't need either one of those things, right? For a variety of reasons. Maybe we don't need an exclusion, or it's not appropriate to use it, or similarly, we don't need, or it's not appropriate to require integrity obligations here. And so really then it's just, a monetary recovery.
So how do you go about, and how does the OIG go about evaluating that? What are their priorities? How is it different from maybe DOJ, U.S. attorney priorities and their focus? Like, so what's the difference in what you're looking at, and how are you coming at it? And what are the things that you're looking for to kind of really kind of focus and ground your analysis?
Yeah, I think that it's the priorities that DOJ and the OIG have. I think they're largely aligned. in terms of, wanting to make the federal healthcare program whole, protect its beneficiaries, make sure that providers and entities are sort of playing by the rules that CMS sets forth. I think there's a lot of overlap in there, and again, the presumption, it's a rebuttable presumption for exclusion. I would say that as a general matter, if exclusion is on the table, the likelihood, there's a very strong likelihood that if that is the case, that you as defense counsel are going to get introduced to the OIG attorney a lot sooner. But I would just say, in the context of FCA cases, those exclusions do happen, but the vast majority of the cases settle either with integrity obligations attached, or with just a monetary settlement only.
There's a public statement that the OIG and the U.S. Attorney's Office are focused, over the last 5+ years on individual liability, right? And these individual exclusions, while maybe they're not as frequent as some of the other things of administrative oversight, but what is it that how are you evaluating that risk? Like, how are you going in there and look, what is it you're looking at that you're concerned about that makes you say this is more of an exclusion candidate versus, or an exclusion entity, versus person, or versus not, or something smaller, or nothing at all? Like, what are the things that you're focusing on at that point?
Yeah, so
One category versus another.
Right. So I think it's important to recognize that sort of OIG evaluates risk on a spectrum or on a continuum. So those, the on the one end of the spectrum, it's sort of the least risk possible, and and on the opposite end of the spectrum, you have like someone who's an individual or entity who's like super high risk, right? And maybe they become high risk because, and it's the same sort of analysis with individuals, right? If you take particular, like some sort of a healthcare fraud, they would be looking at things like, has this person had a prior history of healthcare fraud? Have they, what's the misconduct that they're looking to settle? How long were they engaged in that misconduct? Did they continue to engage in the misconduct after they became aware of the fact that they were being investigated? Is there evidence of any patient harm? And really in that space, you're talking about sort of quality of care, physical harm or neglect, or things like that. So those are some of the things. And then of course, what's the dollar amount at issue, right?
Right.
So certainly, if it's into the millions, obviously that represents a huge loss to the program and a huge risk to the program. And obviously the OIG has an interest in protecting the integrity of the programs.
So what's really critical for, I think, our listeners, out of kind of trying to pull out what's really important there. The thing that stands out to me is this idea of the severity of, kind of, I'd say, like the intent, the level of the intent and malfeasance here. And providers, I have a wide range of behaviors that come across my desk, but there's a fear of correction sometimes. They're saying, yeah, even if I know it, I'm going to be admitting it and things like that. And to me, a big takeaway is, no, if it's something that you now become aware of, it's time to fix it. Like, that's conduct that is going to benefit you, at least in respect to putting your lawyers certainly in a better position and yourself in a better position to avoid exclusion, right? Like, if you just keep beating that same drum and ignoring that conduct, now that you're aware of it from an investigation, is not really helpful to the client.
Yeah, that's not helpful at all. And I would actually do one better, right? And go back to something that we talked about in the very first session, or the first webinar, was, if CMS and the federal healthcare programs generally are not expecting providers to be perfect, right? There's an understanding or an acknowledgement that, things happen, mistakes are made, things of that nature. And so, one of the biggest things I would want to stress to our listeners is really there is the value in being proactive is you're in such a better position to negotiate with the government when you're proactive about something versus waiting for them to come knocking on your door,
Right.
right?
That's
So
exactly what we talked about. That's
yeah,
true.
so to that extent, I would say the best way that you can put yourself in the best negotiating position possible with the government is to have a complete and robust compliance program that hopefully catches these things on the front end, and then you can avail yourself of the self-disclosure process rather than waiting for someone to come knocking on your door, and then certain of those options are then foreclosed for you, and then the road is just bumpier than maybe it needs to be.
Right. But here, right, exactly. But, so now in this context, though, but here we are,
Yep.
um, for, um, for our clients, and, being able to show them being the OIG that you're going to go in now. This is a great segue for like the negotiation and settlement process. So what becomes effective? What's negotiable, and what have you seen that's been effective for counsel and the clients to be able to kind of maybe walk this exclusion back off the ledge. And
Yeah, it's
so
a great question, and
obviously the corrective action here, addressing problems, is one of them. But like,
yep.
let me leave that question for you to answer.
Yeah, so I mean, it's a great question, right? So if you've already sort of stepped in it and you can't unring the bell, right? How do you navigate that situation more adeptly? And one of the things that I appreciated about the OIG, and one of the things that I and others always do is, when we are in this good faith negotiation posture trying to settle a particular matter, we want to give the OIG wants to give the defense attorney or the client, the opportunity to put forth any information or evidence that they think would, so to speak, lessen the sting, of a particular penalty or outcome. And so, I have had over the years, I've had defense counsel ask to submit something in writing, explaining why it is that, in their opinion, they feel that the client should not be excluded, or why maybe the government should consider using a different multiple, or even things like wanting to refine the scope of the covered conduct, or the description of the covered conduct. And then separately, we can get into this later, but it's also a lot of those conversations also revolve around um, integrity agreements, right? And how those kind of are put together. But so I would say the most common things that I have seen, and successfully, right, are providers who, when given the opportunity to respond or to provide supplemental information to the OIG, whether it comes in the form of a written submission, whether it comes in the form of a PowerPoint presentation, an in-person meeting, those types of things. If the government is giving you an opportunity to make your case or to state your case, you should always take advantage of that. And in particular, in a space or a phase like this, where the idea behind everybody is trying to get to settlement, right?
Right. Okay. So what, okay, great. You come in, you do your presentation, you're asking for things, you're trying to show, the importance of corrective action, your compliance program, things that you've helped the client institute along the way to ensure that the conduct really that was the concern and the reason giving rise to this False Claims Act and the liability is trying to say to the government, you don't need to worry about this anymore. We've kind of self-monitored. So you do that presentation, you're arguing for those things, but certain things are not on the table, right? So what are things that the OIG won't get into or won't negotiate?
So in those settlement agreements for the FCA, you'll see that, provisions like things requiring the settling party to cooperate with the DOJ or with OIG in furtherance of additional investigations that they may be pursuing. You see different types of reservations about, or releases related to different types of liabilities. Some of those liabilities OIG can't release. For instance, like something like an IRS or tax liability, right? Like that's not the OIG's authority, so they can't release it. There's other things like mandatory exclusion that will always be reserved in the OIG's or in these types of settlement agreements because the OIG doesn't have the authority to give a release for that because it's a congressionally mandated act, penalty. And again, those mandatory exclusions are largely related to things where people are convicted, where there's a criminal conviction. But so the releases that the target would expect to see in there, for instance, would be related to OIG's permissive exclusion authorities. So those are, so the nature and the scope of the releases are really kind of set. And I think too, as well, you may see, OIG is not going to move on two other points. Well, the one is, if the target enters into sort of a payment over time scenario,
Right.
uh, to resolve to pay back the money that they owe. You'll oftentimes see in those settlement agreements language that OIG inserts related to default for exclusion.
Okay.
So if you, or sorry,
If you
exclusion.
blow it, you're getting
Yeah,
excluded.
if you don't
Right.
make your payments, then OIG is going to exclude you from participating. And
Right.
attorneys have tried to sort of push back on that and say, is there any way we can get that out of here? The answer is no, right? They're not going to do that. And similarly, a lot of times, the other thing that folks will ask about is OIG's communication of the settlement to the public. On OIG's website, they maintain these little blurbs, kind of giving a very high level overview of the settlements. And a lot of times, because providers are understandably interested in sort of protecting their business or trying to minimize reputational harm, they'll oftentimes ask, hey, is there any way that we don't have to post this, on OIG's website? And OIG would say, sorry, that's part of the drill, right?
Yeah.
It's non-negotiable.
So in proving that our conversations are actually dynamic, um, and not rehearsed, let me ask you this question that I don't think we've ever talked about is,
Okay.
is there anything that you've seen that you would say is really ineffective when trying to kind of walk exclusion or maybe the severity of certain oversight obligations back? Has there been things either through counsel or clients, providers have done that you would say is you shouldn't really go that route? Or
Yeah, I mean, the first thing that comes to mind is generally being uncooperative or argumentative, with the government. I think that there is a way to communicate a client's position with the government, that explains to them why it is that, the client shouldn't be excluded or why the money that's going to be repaid should be less or something like that. I would just say that having a spirit of cooperation and, it goes a long way, I think, to leaving the OIG more probably open to things that you may ask about or ask for in the course of a negotiation. And then I think the other thing that folks should understand is that there are certain times where the OIG attorney is not going to not going to be able to implement or accept a proposal, right? And sometimes it's not because they don't want to or sometimes there's that internally that it's just something that the office doesn't do. So
yeah, that's a great point. And to lead to another question, so so who has to then approve? Let's say I'm having negotiations with you, and I'm trying to make a point. Let's say you do agree. Who does that have to go up to for, approval? Is it something you're doing beforehand, or is it? And then let's say you just feel like you can't get through, um, to the particular, let's say, a line attorney you're talking to. Is there other people that you would try to, if it was that critical to ask, or are there other stakeholders either in CMS or anything that you could try to, pull into any of these things? Have those ever been effective? And just kind of give us an outlook on those.
Yeah, so I would say, first of all, it depends on what the ask is from defense counsel, right? There are certain things that, as an experienced healthcare attorney who's done compliance work and done this type of work for many years, there are certain questions that I'm asked that I know the answer to, either as a yes, like so, for instance,
Right,
one of the yeses might be, hey, can we have if it's not in there, can we put a paragraph in there about no admission of liability? Yeah, we can do that. No problem. Hey, my client's going to need 6 months to pay this back. Can I get that flexibility, that payment flexibility? Sure, no problem. Do I have to submit financial disclosure documents to get 6 months? Nope, you don't. Right? Like there are certain things that I can answer. If you want to go more than 6 months, then you're going to have to show me financial hardship, right? And that
right.
requires X, Y, and Z. So there are certain questions that I'm going to know the answer to offhand. There are going to be other questions that I know, for instance, like the ones we talked about, that it's going to be a hard no, no matter what. And I don't have to take those to management, right? Which is like, hey, can we not put this on OIG's website? Sorry, right?
Right.
That's going to be a hard no. And then there's some different ones that maybe come up from time to time. Like, for example, the client or the attorney for the client maybe wants to, tweak the language of the covered conduct, right? That's a pretty common one. And that might be a situation where the line attorney has his or her own feelings about it, but, in the interest of wanting the client's position to be heard, by essentially other decision makers, they'll take that to first, they'll take it to their deputy. Again, remember, in ACRB, each team has a deputy, and then and then there's gonna be the head of all of ACRB, right?
Okay.
So initially, if you and I were trying to settle a case, and I was at OIG, and you said, hey, Dave, I want to try to like insert this language or describe the covered conduct differently, and I'd be like, let me see if I can do that. I can't make any promises, so I'm going to go talk to my deputy and say, hey, listen, I'm trying to resolve this thing with Rob, and his client, and he's asking about modifying the covered conduct language in this way, right? And just sort of take their
But what
temperature
if
on.
I say, Dave, you're the worst? There's got to be somebody else I can talk to. Is that something that's ever entertained, or not so often,
I
or
will, I will tell you, in my time, thankfully, I've never had anyone say that to me. And I've usually been able to navigate some pretty difficult conversations with some grace. But I guess certainly to the extent that if someone felt like the conversation was, sort of going off track or going in the wrong direction, I mean, what I would probably say is the first order of business I would say would be like, okay, listen, it seems like we're having some trouble, communicating with each other. Would you be willing to bring your deputy on the next call so that we can sort of try to get this thing unraveled?
right,
And that's I don't think that's not a terrible ask, and I think could bear fruit just to have a second set of ears or someone else, kind of with a different experience help kind of untie this sticky knot if you're there.
yep. And then, so let's then bring it kind of home to the resolution phase here, right? And
Mhm.
um, why don't I let you kind of talk about what happens at that stage? So,
So
have an
yeah,
agreement.
so again, we touched on this I think a little bit before, but there's going to be the draft settlement agreement, and assuming that everybody can get all the issues hammered out in that draft settlement agreement, kind of once there's an agreement in principle, that is kind of set aside for a moment, and let's just talk about, um, a situation maybe where the OIG says, listen, we think that this provider needs, some sort of integrity agreement, right? And so that at that point, you'll usually see DOJ drop out of the conversation, and then OIG and the defense attorney or the provider or whomever, sort of you start anew on negotiating this other piece, of the settlement. And the reason why you'll see this is because, generally speaking, and rightfully so, clients want, they want a global settlement, right? They want to know that once they settle this thing, it's going to be off their plate, off their back, whatever. And so so that's why you see both DOJ and OIG in a lot of those settlements, in particular because there's certain OIG authorities. But in the interest of trying to sort of get closure on it, that's why the OIG is there. And so then there's a separate negotiation with the settling party about whether, assuming that there's an integrity agreement that's needed, kind of what that looks like.
Right. And so what are the kind of common elements of an integrity agreement?
Yeah. So
What should providers expect?
yeah. So over the years, OIG's approach to integrity agreements has changed. What's changed about it is a couple things. Number one, there used to be a point in time in the healthcare space where, compliance programs were non-existent. And so in those instances, in the early years, OIG would require integrity agreements with every provider that they settled with who wasn't getting excluded. Over the years that approach has obviously evolved, and that the integrity obligations or the requirement to have those have shifted over the years, in part because of workload of the attorneys who would be responsible for monitoring them on the back end, but also just sort of in recognition of knowing that agreeing to integrity obligations, it's a long-term commitment, for 3 to 5 years. And so the OIG wants to make sure that they, have the resources to do it. And that if you're going to spend all that time working with a provider to improve their compliance, you obviously want to make sure that it's worth doing. Right.
All right. And then what about, so let's say you reach the terms of these agreements, usually, these are usually compliance type things, whether we're implementing compliance programs, in my experience, typically hiring outside organizations to be an independent review monitor
Mm-hmm.
or an IRO organization. I'm familiar with the process. You have various delivery dates where you have to get these things done by. You have to submit proof to the OIG. But it's not usually the same attorney assigned to it, right?
Right. Yeah. And I apologize. I think you asked me one other question about some common elements in the CIA or integrity agreements, right? But as a general matter, and I can touch on that momentarily, but as a general matter, once the case is settled, then the integrity agreement gets sent to another attorney within ACRB, right? And they do that just because they want, they want someone who's going to come in as an objective individual, someone who was not sort of maybe involved in the negotiation of the settlement. Sometimes those settlements get tense and things like that, and so they want an objective person to come in. So you'll have a different attorney be your monitor for either a 3 or a 5 year period, depending on what is expected.
Right. Right.
And then I would say that again, there's some common elements into all of these agreements, as you mentioned, right? Some of them are things like hiring, making improvements to an existing compliance program, hiring what's called an independent review organization to help the entity or the provider
Right.
conduct reviews at regular intervals. And then there's a whole bunch of different reporting requirements that OIG has built into these agreements for things like overpayments and reportable events, and these types of things, that there are certain requirements that the provider notify OIG when something happens, or for example, if they're trying to sell the practice, right, when in the midst of an IA, right? There's certain things that are in all these agreements. Again, there's going to be things about the need to do things like establish a confidential disclosure program, refrain from hiring excluded persons, right? There's all sorts of things that you'll see in all of these things. But I would say that as a practical matter, the most commonly negotiated provisions of those integrity agreements are the type of review that's being asked, the scope of that review, including definitions of key personnel, like who constitutes a covered person, or a covered arrangement, and then things like due dates and expectations for training, and even maybe IRO selection. Those are types of things that are commonly asked about.
Right. So
And some
what
of
happens then though? Like, so we get the agreements, we've negotiated all these provisions, we now understand their obligations, and our clients or providers are out there providing their services and complying with these provisions. And in the simple world for our listeners, there's delivery dates. We have to accomplish certain tasks by certain dates over a period of time. And we have to have this oversight body conduct certain audits and cooperate with them in order for that material to get sent to the OIG. Where do you see providers who are under these integrity agreements run into any kind of problems? How can you kind of avoid sanctions for there could be some pretty hefty sanctions in these agreements for failures. And what can you do to avoid them?
Yeah, so I would say that sort of the most common missteps sort of fall into two buckets, right? One is things that are related to the performance of the integrity agreement itself. So, for example, as you mentioned, there's certain deliverables that have to be provided to the OIG by certain timeframes. One of the biggest mistakes that I see providers make under those agreements are that that they know that they have a deadline coming up, and for whatever reason, they're not able to make that deadline. Communication goes a long way, right? As a monitor, as someone who has monitored a lot of these integrity agreements, I always appreciated it the most when either a provider or counsel would call me and say, "Hey, listen, I know that the client has an annual report that's due on, December 12th or whatever. For a variety of reasons, they're not going to be able to make the date.
Right.
Maybe the IRO is on vacation. Maybe there's other things happening. Maybe there's a personal matter. Life happens, right? And so I would say that as a practical matter, the OIG is much more lenient. I don't know if lenient is the right word, but more apt to work with providers when those providers are kind of giving the OIG a heads up that there's a problem along the way before it becomes a problem, right? You don't want me calling you saying, "Hey, Rob Del Giorno, your client owes us an annual review. Where is it?"
Right.
Right? Um,
And
so I,
what about things that rise to the level of imposing sanctions? Because my experience has been that it's while it's oversight, they're not necessarily looking to be punitive and just continuously punish the provider and impose sanctions. But I've seen it happen. So where do those what are the things that'll really rile you up
right.
with the
So,
OIG?
yeah. So I think that actually dovetails into this idea of like the second bucket where providers make mistakes, right, under
Right.
the terms of an IA. And it has to do with sort of their compliance efforts or lack thereof. And so if you are obligated to be doing certain things like making sure that you're not hiring or employing excluded individuals, right? Or if you know that your compliance program should be doing regular audits to make sure that you don't incur overpayments, right? And you're not doing those things, um, then I think that's what's gonna sort of raise the blood pressure a little bit of the monitor, um, and also just sort of generally going like radio silent,
Right.
right? That's
Okay.
that's another one that's guaranteed to make people uneasy.
All right. I think that really, in my experience, it's covered really my experience. I think it's been great to learn about things like how early there's interaction, because I'll get introduced to the OIG attorney and it's at the very end of the case. And I never understood how much information, how long they've been really involved in the case. And I think that's good for providers to know, and their counsel to know when they're going to interact with the OIG. I think, knowing what's negotiable and not negotiable, or knowing how we're going, what's effective and what will really cost you has been really invaluable information for our audience today. I think I don't think I have any other questions for you at the time, but certainly we have a few minutes. If anybody wants to post a question, we'll we'll be happy to take it. Otherwise, I really appreciate, David, what you've been able to impart over these last three webinars, and I think it's been really great for our clients and our other providers out there just to come and get some information here from our
Yeah, yeah,
clients.
for sure. Thanks for hosting this and letting me giving me sort of a platform to share the knowledge and insight that I've gained over many years at the OIG. And I think it's the sort of the what I would say, some of it is the inside baseball, right?
Right.
About how things work in the government's world, and how those things can be useful to for the client, for our clients.
All right. Well, seeing no questions coming in here, I'll give it another second. But as a reminder, this is recorded, and we'll be sending it out to everybody who registered for it, and we really appreciate everybody joining us today. Our compliance group here, marches on. We'll be announcing another webinar very shortly. I think we've covered almost every month since December. And we'll continue to bring you this, great free content out there for you to come on in and spend your lunch with us and learn something new. So thank you all for joining, and have a great day from everyone here at Garfunkel Wild.
Thank you. You too.
Bye, everyone.